The Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning. Mr. Shaw? Thank you. Thank you.
Chief Justice Marshall, may it please the Court, my name is Robert Shaw and I appear today on behalf of Ronald Belcher. Mr. Belcher was tried by a jury and acquitted of all the charges against him, save a charge of disseminating matter harmful to a minor. There are two interrelated and fundamental reasons that there is a substantial risk of a miscarriage of justice relative to the jury's judgment on that charge. The first is that the jury instruction of the trial judge on what it means to disseminate matter did not require intentional conduct. And second, there was a strong evidentiary basis upon which the jury could have convicted for something less than intentional conduct.
May I ask, are you conceding that dissemination occurred, but taking the position that it was not intentional or purposeful?
Well, based upon what physically occurred and based upon the definition given by the trial judge on what it means to disseminate, the jury could have viewed what happened as dissemination in this case.
But just to follow up on that, I take it what you're saying is to display. The verb to display can be accidental.
Exactly. And it can be accidental, and it fits the definition as provided by the trial judge, because what the trial judge said is that he had to disseminate it, but then went on to define dissemination as only to exhibit or display.
Well, that's not exactly correct, though. I can sort of understand your point if the court had said the material has to be harmful, the defendant had to know it was harmful, the defendant had to have displayed the material or disseminated it, meaning display or exhibit, and the victim had to have seen it. But here, didn't the court say that disseminate means to exhibit or display to the person? Right. Isn't that different?
I don't believe so, Your Honor, and this is why, and I think it's very important to focus on this. The problem is that the words exhibit and display do not necessarily connote intentional conduct.
But display to? If I display something to you, that's different than if I just display something.
Right, but again,
where you might see it.
But if we carry out the example, to exhibit and display can be interpreted as passive. For example, where one places some object on exhibit or display, on a shelf, for example, and the exhibiting or the displaying continue to whoever is in a position to view that matter at a later time, whether or not there is further intentional conduct or any volitional conduct directed at displaying it to the person who views it. And this conduct should be contrasted, for example, with conduct such as punching somebody.
But was that argued to the jury?
There was evidence in the form of testimony, Mrs. Belcher, Mr. Belcher, that this was inadvertent or negligent at most, and there was.
But that wasn't the theory of the case, was it?
Well, it wasn't necessarily the theory of the case. The prosecution.
I mean, didn't he testify that he didn't permit her to see the materials, and he tried to prevent her exposure, and that it wasn't negligent? I mean, isn't that directly contrary to what he was testifying to himself?
No, I don't believe so, Your Honor, and I would like to review that with the court. I will actually specify exactly what that evidentiary basis was, but if the court would allow me, I'd like to just back up for one moment to go back to this example, because it's very important to contrast the conduct at issue with, for example, conduct such as punching. We know that any time punching someone occurs, it is produced by and accompanied by volitional conduct.
But that wasn't the way the case was presented to the jury. I take it the young woman in this case said, he showed it to me. The defendant said, I never showed it to her. And that's the way the case was presented. You either believed one side or the other. And don't you have to read the jury instructions in that context?
But, Your Honor, I don't think that that's a fair approach in this case, because there was a spectrum of conduct from which the jury could have concluded that there was inadvertent or negligent dissemination here.
Yeah, could I just, I'm sorry, but I want to just make sure I understand the facts. Isn't your client's position that there were some videotapes that may have been out that shouldn't have been out, but that she took the videotapes, put them into the machine, and she looked at them on her own? Isn't that his position? Isn't that his position?
Well, she certainly had access and put the videos in the VCR.
Okay, so that's his position, that she was the person who triggered it. She put these videotapes into a machine and she looked at them.
But, Your Honor, that doesn't make a difference, because let's go to the case of Commonwealth versus Rowlands. Someone walks 200 or 300 feet beyond a bus stop and then examines material. It's still dissemination. Let's go to Lawton Book's case. Somebody puts coins in and they take that action, they facilitate the dissemination, but there was still the dissemination or the exhibition or display. So it doesn't matter that she simply did that. She had access to it. They were left in the room where she had access, exhibited and displayed to her.
Mr. Shaw, I take it, as I try to listen to Justice Spina and Island's questions, that first, this is a very small space, right? This is a trailer.
Exactly.
And as I take it, and I don't know who testified to this, but maybe the defendant, maybe somebody else, that they had observed the victim, or they had become aware of the victim watching these videos and had told her not to do that, correct?
Well, they had caught her, right, and they had told her
not to do that. And I thought there was some testimony maybe from the defendant that he had said, is it his wife? Or
Mrs. Belcher, correct,
yeah,
and Mr. Belcher.
That they had to, perhaps take additional steps to make sure she didn't get access. I take it that the child was sleeping in the living room?
That's correct.
Okay. And there were tapes in the living room?
Right.
Okay. So there's no question that it's not just a question of the police seeing adult videos left around. There was evidence that she had watched them and that they knew that she had watched them, correct?
That's correct.
So the jury knew that?
Yes.
Right?
Yes.
And the question then was, it seemed to me, whether the jury believed the Commonwealth's claim, according to the testimony of the victim, that the defendant had watched with the child, correct?
Well, that's what the complainant said.
Yes, of
and
course.
that's
So in other words, there's no dispute, because the defendant has testified to the fact that these adult videos are openly displayed, that the defendant knew that she had watched them on more than one occasion, correct?
Correct.
So it comes down to whether or not the jury was instructed that they had to find that this defendant had watched, in essence, with this victim.
Well, that's perhaps what the instruction should have
Well, there's
been.
no dispute about any of the other facts.
Not really, not really.
Right.
I mean,
So
the instruction was
So the
only...
disputed issue is, and then the question is, to use Justice Cordy's phrase, if you are then instructing the jury, disseminate to, in the context of that trial, why would the jury be confused? Because that's the disputed issue.
Well, Your Honor, and let me address that in one way and then go right to the evidentiary basis, because I think it will clear a lot up for the court.
Okay.
If I put a video on a shelf in my living room in the privacy of my own home, and a week or 2 weeks later somebody stands before that shelf, that video is displayed to that person, despite the fact that I did not have the intentional conduct.
But that's not in dispute in this case. Everybody's agreeing to that.
Okay. And so let's go directly to the evidentiary basis, because there was a strong evidentiary basis, again, for the jury to find and convict based on less than intentional conduct. Mrs. Belcher's testimony. She testified on 3 separate occasions that she knew adult videos had likely been left in the room where the minor slept. That's at volume 2, pages 188, 209, and 210. She testified that she went and found, on one occasion, the minor watching the video.
All of that evidence, the Commonwealth never disputed that. The Commonwealth never disputed that.
Well, Your Honor, in the appeals court, the Commonwealth argued quite strenuously that there was no basis in the evidence for the jury to look and say there was an inadvertent or negligent exhibition or display. And the fact is that there was a wide spectrum of evidence from which the jury could have looked.
Well, I don't know what they argued, but I'm just talking about what the facts are before the jury.
Right.
Because it seemed to me that the defendant, the police officer testifying, I'm walking into this relatively small space.
Right.
Correct?
Right.
And I'm seeing adult videos openly displayed,
Right.
to use your words.
Right.
And the defendant himself is saying, I know this child watched at least on 2 occasions.
Right. There were at least 4 occasions testified to.
Okay.
That's correct. And he testified, I would also note, that he should have been more cautious about putting them away, collecting them up and putting them away. He was angry at himself for not doing it. He was concerned about the fact that the minor had repeatedly had access. And the approach of the Commonwealth and the approach of the prosecution was to, ask questions like, chances are she got it off the entertainment shelf, right? And it would have been easier for her to find them because they were all over, correct? These are questions asked by the prosecutor. And so there really was a very strong basis for the jury to look at the evidence and convict for something less than intentional conduct. And I would also point out, and I think it's very important, the jury, if the jury rejected in whole or in part the complainant's testimony in this case, and we know that the jury did so because they acquitted him of all other charges, the jury was still required to then look at the instruction given by the trial judge to see what does it mean to disseminate, and then to look at the facts that they found credible and believed, and then refer to that jury instruction to determine whether dissemination under the facts of this case, under the facts that they credited and believed, constituted the offense of dissemination. And that's the problem we have in this case, is that there was a spectrum of evidence. This is no different than the case of Commonwealth versus Collier, where there was the opportunity for the jury. In that case, for example, the Commonwealth argued that the defendant was in the car and had intentionally violated an abuse order. The defendant's argument in that case was, that wasn't me, it was mistaken identity. This court looked at the situation and said, yes, but if they rejected the defendant's testimony in that case, the jury would have had to look and answer the question about intent. And the same is true here. And there are other cases, Commonwealth versus Schmuckler, which talks about the fact that where there was no instruction as to fraudulent intent, and that was essential to the conviction, there was a substantial risk of a miscarriage of justice given the fact that that instruction wasn't given. Are there any other questions that I can answer?
Thank you, Mr. Shaw.
Thank you.
Ms. Lee?
Good morning. May it please the Court, Mary Lee for the Commonwealth.
Ms. Lee, may I ask you just this question? I'm looking at the jury instructions, and I think you understand, at least what my understanding of the undisputed evidence. In other words, these videos were freely available to anybody who walked into that room. Is it the Commonwealth's position that if a large number of harmful material, a large number of harmful to minor videos is available, and the defendant knows that this child has on 4 occasions, I think it was 2, but on 4 occasions has herself watched the video, and that the defendant then continues to store, keep, leave about, whatever words you want to use, those videos while inviting this child back into the house, that in and of itself is sufficient, or does the Commonwealth have to prove that the defendant took one of the videos, put it into a VCR or some other, display thing, and turned it on for the child?
May I ask one question about your hypothetical?
Sure.
Is the defendant present when the child is doing those activities, placing a video in to watch it?
I don't know, because I presume I would, in my hypothetical, say turn it on and say to the child, watch, and then the defendant leaves the room. So I don't know. But I mean that the defendant activates the video.
There's a scienter requirement, obviously. So, and that requirement under the Constitution is knowledge, which was accurately instructed in the jury instructions.
Right.
So on your hypothetical, which is different from the case at hand, but on your hypothetical, if the defendant knew what was going on, then he may be held responsible for that indirect activity.
Now, what's the best case then? In other words, what I have here, as I understand it, is let's just say videos left lying around, right?
Right.
Defendant has knowledge, admits, testifies to knowledge. That child in those circumstances takes video. Let's assume she takes them herself, that he comes across her or she tells him, whatever it is. And then defendant continues to display, to leave it lying around.
I believe In those circumstances, a defendant could be responsible for that. I think there was a case, I'm sorry, the name of it escapes me, where a man had pornographic magazines in the back of his car, and he was near a beach, and was permitting the children to go look at the pornographic magazines. And so in that situation, he knows exactly what's going on. He knows they're going and looking at it.
He didn't go and say, come and look with me.
Right, and he can be held responsible for it. And you obviously, in all cases, you derive the proof of intent from the person's actions. So, and you can be held responsible for things that other people do, for example, in joint venture cases. So if someone else were in the room and you said, okay, I'm not going to stay in here, but you show Junior the videotapes, then obviously, that's a very clear situation where the defendant would be responsible. But that's not the situation we have in this case. In this case, we have instructions that say the matter has to be harmful to a minor, the defendant must know that the matter is harmful to a minor, and that the defendant disseminated to a minor, and then that is further defined as the defendant exhibited or displayed that matter to a minor. And to answer Justice Cordy's question from earlier, every time they describe dissemination, that language to a minor or to a person under the age of 18 is indeed following the word dissemination, exhibit.
I take it your position in this case is that those instructions which you've just described were adequate based on the evidence, but for the future we should say the judge should put in an instruction that the defendant has to do this intentionally.
Yes, intentional and purposeful conduct.
Right, to rule out accident and negligence.
Exactly. And there was no request for an accident instruction in this case, nor was one given. There was also no description of joint venture or third-party, actions that the defendant would be responsible for, or even the words, indirect dissemination. Those don't appear in the instructions.
I understand. I understand. On the one hand, what giving that instruction to the jury might accomplish. But it seems to me that if you're insisting that you have to say that he intentionally did it, I'm not sure that you may be conceding too much. In other words, on this factual pattern, where this defendant knew, I mean, it's a little bit like the back of the car. You know that this is what this child is doing. And you then, we try to keep it out of the bedroom, but we knew that we weren't doing that. It seems to me that if you place highly harmful material in front of a child, knowing that the child knows where it is coming in, why do we have to tell the jury that you intentionally did that? It's like negligence.
And, I'm getting that language from Horton and Rollins.
I understand, but those are different fact patterns.
I agree. And in Rollins, there was no actual dissemination.
But it strikes me that in the circumstances the Chief Justice has described, presumably that would be circumstantial evidence of intention.
Intent, yes. And also, when there is an actual dissemination, the jury can infer that it's intent, and that's from Lawton Books.
If the jury believes that he sat down with her, but the defendant says, and for purposes of this I have to accept that the jury didn't believe that because they rejected a lot of her testimony, so they may not have believed that he actually sat down next to her and watch the video with her, correct?
I would suggest to the court, no. I think that, first of all, I'd like to address the weakness argument, the weakness of the case argument.
Yeah.
Granted, the jury rejected several of the charges on rape, indecent assault and battery, and incest, and they convicted on this sole charge of dissemination of matter harmful to a minor. But this was the only charge in which the victim was corroborated. The victim had a lot of problems. Her IQ was 48 or 49. And she had a great deal of difficulty in testifying, and she was even impeached sometimes by her mother's own testimony about her prior actions. But this was the charge which the victim was corroborated. She went to her mother and she said, there is a photograph that the defendant showed me of him and his wife naked, and they're doing a sexual act. And, of course, she's not using it in that language, but she conveys that to her mother. And she says, and he showed me another picture of himself and another woman, also naked, doing a sexual act. Oh, and he sat down and watched this video with me of naked people playing with each other. When the police go and execute the search warrant in that home, They find that photograph of the defendant and his wife. They find that photograph
But
of the
that's not
defendant and
evidence
another
that
woman.
the defendant showed it to her. She could have seen it.
But it corroborates that she had knowledge of inappropriate materials in that
that's my
home.
point.
Yeah, but
So
that's
I would
the
suggest,
issue, yeah.
I don't have to concede that the jury rejected the defendant's story, I'm sorry, the victim's story on this matter, because this was the one charge where she was corroborated. There's a good reason why the jury would believe her. So let's look at the case in the context of the instructions that were given and the facts and the closing arguments, as we must. We know that the jury has to find that he had knowledge of the matter, that it was harmful to a minor, or it's a not guilty. If she's disseminating that matter to herself in secret, he doesn't have that knowledge, scienter isn't met, and the jury can't reach
What
that.
about the scenario that he, could the jury have convicted the defendant believing that he left the material out there, period, and thus enabling her to see it? Would
That's
that be
my
sufficient
point.
for a conviction?
No,
Knowing that in the past,
not on these instructions. These instructions have active voice throughout them. Defendant disseminated matter to harm. Defendant exhibited or displayed
Right, but
to a minor.
exhibited being put out in front of her, put
Oh,
out
no,
where she was.
you mean the packaging?
Just that the pictures were available so that she could see them. Is that sufficient on the instruction?
If they had them hung on the wall or out on a table and she saw them, yes, that would be
in
sufficient.
in a drawer.
In a
If the
drawer,
evidence was-
hidden in a room where she wasn't permitted to go into, no.
But they knew she had been in there.
She had been in there against the defendant's orders and without permission, and then was ordered out of the room. The jury cannot possibly have taken the words exhibit or display to be consistent with the defendant's story that he hid the videotapes and she would ferret them out and watch them in secret in the middle of the night while he slept. That doesn't meet the scienter requirement. That doesn't meet the active dissemination by the defendant. It's the victim disseminating the stuff to herself. And there's no third-party liability, joint venture, passive voice, anything in these instructions. So even if in another case with the instructions that say intentional and purposeful, that you might have a defendant being responsible for someone else's conduct, the law of the case here are these instructions. And these instructions say this defendant has to disseminate this himself, well, it doesn't say himself, disseminate matter that he knows is harmful to a minor to this victim. If the jury found that the defendant did not disseminate that matter, then they find him not guilty. So on his story, he's not guilty.
Can I ask you this question? There's no question that I don't think the defendant challenges the matter that the matter was harmful to minors. Right?
Clearly, that's right.
So I don't know what the evidence is, but I take it, leaving aside the photographs, that at least as to the videos, that there's nothing on the cover.
There's no description of the cover of the videos. There's
Okay.
no
So
description that
it's-
she ever saw the covers. She does not tell about seeing them. The police do not describe what's on the covers. And in fact, when the victim's wife testified that she caught the defendant's wife testified that she caught the victim watching the video, she said there was no place on the shelf for the video. So even the wife did not describe the covers.
So that we can assume
no
there
evidence
was
on it.
no evidence, so that if once the jury find that the matter was harmful,
Yes.
I don't know what I'm doing with the photographs at the moment, but at least it's the video. It means watching the video. And then when you take that in connection with the defendant disseminated I'm reading from the jury instructions, the defendant disseminated the harmful matter to a minor.
Yes.
You're saying, I don't need intentional here.
Exactly, on these facts, because the jury is choosing between two sets of facts. One is the defendant didn't disseminate, the victim disseminated, she did it in secret when he had no knowledge of what she's disseminating to herself. And when he and his wife discovered her, he discovered her 3 times, the wife discovered her once, they went in, stopped the video, took the video out of the machine, took it away from her and said, you know you're not supposed to be watching it. They were prohibiting the exhibition and display of it on their testimony. And the victim's testimony only describes intentional conduct. He sat with her and committed a sexual act on himself in front of her while he watched the video in his blue bathrobe. And the police found the blue bathrobe. They found the videos. They found the pictures that she described. So she's corroborated on this charge. So you want an explanation why the jury rejects everything else and only convicts on this? Because this was the strongest charge. She was corroborated. She knew in advance before the police got there that those pictures were there. How did she know? She saw them. So then the question for the jury is, who showed them to her? Because that's what is required on these instructions. The defendant disseminated matter to a minor. Disseminated means exhibit or display. And the defendant here relies on the definition of exhibit and display and show in Latin books to include permit to be seen. The jury was never given that instruction on permit to be seen, but even if that is a synonym for that, the defendant's testimony, which is the only other explanation aside from intentional conduct, does not come within permit to be seen. He was prohibiting her from seeing it. She was forbidden to go into his room. They hid the videotapes. When she found them and was watching them and got caught, they took them away and reprimanded her. No one in their right mind can think that that means permit to be seen.
So what you're saying, in other words, I think, if I understand your argument, is that the judge's instruction that the Commonwealth must demonstrate beyond a reasonable doubt that the defendant exhibited or displayed a harmful matter, that the use of those words encompasses within it that he did something intentionally.
Yes.
That's your argument in essence.
Particularly with the knowledge, the scienter requirement, which is correctly explained in there. And in addition to that, the closing arguments do not raise any kind of accidental negligent liability in this case. The defendant argued he never showed these movies to the victim. He never showed her any naked photos. And the Commonwealth's argument was, it's dissemination when you're showing pictures to your niece with you and your wife and some other woman engaging in sexual conduct. And that's at transcript 3, page 122. The theory of the Commonwealth's case was that the defendant was showing these pictures to the victim, and the defendant's claim was a denial. She showed them to herself. Unless there are any other questions, I would rely on my brief for any other comments. And I would ask the court to affirm the conviction in this case. Thank you.